Another day, another story. Section 84. Act of a person of unsound mind. Nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Section 85. Act of a person incapable of judgment by reason of intoxication caused against his will. Nothing is an offense which is done by a person who, at the time of doing it, is, by reason of intoxication, incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. Section 86. Offense requiring a particular intent or knowledge committed by one who is intoxicated. In cases where an act done is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. Section 87. Act not intended and not known to be likely to cause death or grievous hurt, done by consent. Nothing which is not intended to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause, or be intended by the doer to cause, to any person, above 18 years of age, who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Illustration: A and Z agree to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which, in the course of such fencing, may be caused without foul play, and if A, while playing fairly, hurts Z, A commits no offense. Section 88. Act not intended to cause death, done by consent in good faith for person's benefit. Nothing, which is not intent to cause death, is an offense by reason of any harm which it may cause, or be intended by the doer to cause, or be known by the doer to be likely to cause, to any person for whose benefit it is done in good faith, and who has given a consent, whether express or implied, to suffer that harm, or to take the risk of that harm. Illustration: A surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under the painful complaint, but not intending to cause Z's death, and intending, in good faith, Z's benefit, performs that operation on Z, with Z's consent. A has committed no offense. Section 89. Act done in good faith for benefit of child or insane person, by or by consent of guardian. Nothing which is done in good faith for the benefit of a person under 12 years of age, or of unsound mind, by or by consent, either express or implied, of the guardian or other person having lawful charge of that person, is an offense by reason of any harm which it may cause, or be intended by the doer to cause, or be known by the doer to be likely to cause to that person, provided, provisos. First, that this exception shall not extend to the intentional causing of death, or to the attempting to cause death. Secondly, that this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death, for any purpose other than the preventing of death or grievous hurt, or the curing of any grievous disease or infirmity. Thirdly, that this exception shall not extend to the voluntary causing of grievous hurt, or to the attempting to cause grievous hurt, unless it be for the purpose of preventing death or grievous hurt, or the curing of any grievous disease or infirmity. Fourthly, that this exception shall not extend to the abatement of any offense, to the committing of which offense it would not extend. Illustration: A, in good faith, for his child's benefit without his child's consent, has his child cut for the stone by a surgeon knowing it to be likely that the operation will cause the child's death, but not intending to cause the child's death. A is within the exception, inasmuch as his object was the cure of the child. Section 90. Consent known to be given under fear or misconception. A consent is not such a consent as is intended by any section of this code, if the consent is given by a person under fear of injury, or under a misconception of fact, and if the person doing the act knows, or has reason to believe, that the consent was given in consequence of such fear or misconception, or consent of insane person, if the consent is given by a person who, from unsoundness of mind, or intoxication, is unable to understand the nature and consequence of that to which he gives his consent, or consent of child, unless the contrary appears from the context, if the consent is given by a person who is under 12 years of age. Section 91. Exclusion of acts which are offences independently of harm cause. The exceptions in sections 87, 88 and 89 do not extend to acts which are offences independently of any harm which they may cause, or be intended to cause, or be known to be likely to cause, to the person giving the consent, or on whose behalf the consent is given. 27. Illustration: causing miscarriage, unless caused in good faith for the purpose of saving the life of the woman, is offense independently of any harm which it may cause or be intended to cause to the woman. Therefore, it is not an offense, by reason of such harm, and the consent of the woman or of her guardian to the causing of such miscarriage does not justify the act. Thanks for watching.